Rule 20.01. In determining the amount of fees, a lawyer shall be guided by the following factors. 1. The time spent and the extent of the service rendered or required. 2. The novelty and difficulty of the questions involved. 3. The importance of the subject matter. 4. The skill demanded. 5. The probability of losing other employment as a result of acceptance of the proffered case. 6. The customary charges for similar services and the schedule of fees of the IBP chapter to which he belongs. 7. The amount involved in the controversy and the benefits resulting to the client from the service. 8. The contingency or certainty of compensation. 9. The character of the employment, whether occasional or established. And 10. The professional standing of the lawyer. The determination of the amount of attorney's fees based on Rule 20.01 of Code of Professional Responsibility involves questions of fact. Nature of services. The value of the lawyer's services is in large measure determined by the nature, quality, and quantity of such services. His competence is judged by the character of his work. The importance and value of his work shall be measured and considered as a whole. Skill and standing of attorney. The skill, experience, and standing of a lawyer bear a direct proportion to the amount attorney's fees to which he may be entitled for his work. The ability, skill, and competence of a lawyer must not be measured by his income. The lawyer's competence and ability must be judged by character and quality of his work and services not only in the field of law but in the other field of private and public endeavors. Value of interest involved. Generally, the bigger the size or value of the interest of property involved in the litigation, the higher the attorney's fee is. Reason: the higher the stakes, the more the case is highly litigated and the greater the efforts the lawyer exerts. Difficulty of issues involved. Novel or difficult issues involved in a litigation require greater efforts on the part of the lawyer in terms of preparation, study, and research. Whether fee is contingent. A lawyer may properly charge a higher fee for his services when the fee is contingent than when it is absolute. Absolute fee arrangement entitles a lawyer to get paid for his efforts regardless of the outcome of litigation. Contingent fee arrangement, a lawyer assumes of getting not paid for his services. He may not even get reimbursement for advances of litigation expenses if the client is poor. Capacity of client to pay. The financial ability of client to pay must be considered in determining the amount of fees. Statutory limitation as to fees. Article 111 of the Labor Code. It shall be unlawful for any person to demand or accept in any judicial or administrative proceedings for the recovery of wages, attorney's fees which exceed 10% of the amount of wages. Eugenio E. Cortez versus Attorney Hernando P. Cortez, March 12, 2018, Administrative Case Number 9119. Facts: Eugenio E. Cortez engaged the services of Attorney Cortez as his counsel in an illegal dismissal case against Philippine Explosive Corporation. He further alleged that he and Attorney Cortez had a handshake agreement on a 12% contingency fee and by way of attorney's fee. The case was decided in favor of the complainant. Philippine Explosive Corporation was ordered to pay complainant the amount of 1,100,000 pesos in 3 staggered payments. PSC then issued checks all available in the name of complainant as payment. Attorney Cortez, however, claimed that 50% of the total awarded claims belonged to him as attorney's fees. Complainant offered to pay 200,000 pesos, and when his attorney rejected it, he offered the third check amounting to 275,000 pesos, but Attorney Cortez still insisted on the 50% of the total award. Thus, Eugenio filed a complaint against Attorney Cortez for grave misconduct and violation of the lawyer's oath of the Code of Professional Responsibility. The IBP Commission on Bar Discipline recommended the 6-month suspension period to Attorney Cortez. Issue: whether or not the acts complained of constitute misconduct on the part of Attorney Cortez, which would subject him to disciplinary action. Ruling: we rule in the affirmative. We have held that a contingent fee arrangement is valid in this jurisdiction. It is generally recognized as valid and binding but must be laid down in an express contract. The amount of contingent fee agreed upon by the parties is subject to the stipulation that counsel will be paid for his legal services only if the suit or litigation prospers. In this case, we note the parties did not have an express contract as regards the payment of fees. Complainant alleges that the contingency fee was fixed at 12% via a handshake agreement, while Attorney Cortez counters that the agreement was 50%. The IBP Commission on Discipline pointed out that since what respondent handled was a labor case, his attorney's fees should not exceed 10% the rate applied under Article 111 of the Labor Code. Although we agree that the 50% contingency fee was excessive, we do not agree that the 10% limitation as provided in Article 111 is automatically applicable. Generally, the amount of attorney's fee due is that stipulated in the retainer agreement, which is conclusive as to the amount of the lawyer's compensation. In the absence thereof, the amount of attorney's fees is fixed on the basis of quantum meruit, like the reasonable worth of the attorney's services. Courts may ascertain also if the attorney's fees are found to be excessive, what is reasonable under the circumstances. In no case, however, must a lawyer be allowed to recover more than what is reasonable pursuant to Section 24, Rule 138 of the Rules of Court. Canon 20 of the Code of Professional Responsibility states that a lawyer shall only charge fair and reasonable fees. Rule 20.01 of the same canon enumerates the factors which should guide a lawyer in determining his fees. 1. The time spent and the extent of the service rendered or required. 2. The novelty and difficulty of the questions involved. 3. The importance of the subject matter. 4. The skill demanded. 5. The probability of losing other employment as a result of acceptance of the preferred case. 6. The customary charges for similar services and the schedule of fees of the IBP chapter to which he belongs. 7. The amount involved in the controversy and the benefits resulting to the client from the service. 8. the contingency or certainty of compensation. 9. The character of the employment, whether occasional or established. And 10. The professional standing of the lawyer. We believe and so hold that the contingent fee here claimed by Attorney Cortez was under the facts obtaining in this case, grossly excessive and unconscionable. Respondent Attorney Hernandez P. Cortez, of violation of Canon 20 of CPR, is hereby suspended from the practice of law for a period of 3 months and is ordered to return to the complainant the amount he received in excess of 12% allowable attorney's fees.